You ever wonder why some defense attorneys act like they walked straight out of a courtroom drama villain casting call? It is not an accident, it is a tactic. And witness intimidation is one of the oldest tricks in the legal playbook. Imagine you witnessed an accident and suddenly you are getting weird phone calls or someone shows up at your workplace asking questions about you. That is not just creepy, that is potentially illegal interference with a legal proceeding. Here's the wild part. Intimidation does not always look like a mobster movie threat. Sometimes it is subtle, like a private investigator following you around or a company suddenly remembering you broke some minor rule 3 years ago. So why would a defendant even try this? Simple. If a witness gets scared and backs out, the defendant just weakened the plaintiff's entire case without ever stepping foot in a courtroom. Lawyers who specialize in this kind of hostile litigation know the first move is documentation. Every weird call, every suspicious encounter, every uncomfortable interaction gets written down with dates and times like you are building a timeline for a true crime podcast. You might think going to the police is the only answer, but sometimes the smarter move is going straight to the judge. Courts can issue protective orders that legally bar the other side from contacting witnesses directly. Let us talk numbers for a second because people love stats. Studies on litigation misconduct suggest that witness tampering or intimidation shows up in a noticeable chunk of high-stakes injury and corporate liability cases, especially when large insurance payouts are on the line. Now here is a fun twist. Intimidation can backfire spectacularly. If a defendant gets caught trying to scare a witness, judges do not just frown, they can sanction the defendant, throw out evidence, or even instruct the jury that the defendant tried to mess with the process. You know what that does to a jury's trust? It tanks it faster than a celebrity apology video. Good injury lawyers prepare witnesses ahead of time, walking them through what intimidation might look like so it does not catch them off guard. Think of it like training someone to recognize a scam call before it happens, except the stakes are a little higher than a fake prize giveaway. Another smart move is keeping communication formal and routed through legal teams instead of direct contact. This way, if anyone tries to go around the lawyers and reach a witness personally, it becomes a glaring red flag instead of a quiet conversation. Sometimes lawyers even request sealed records or anonymized filings to protect witness identities, especially in cases involving powerful companies or wealthy defendants. It sounds dramatic, but in some situations, it is simply smart risk management. Here is the human part nobody talks about enough. Witnesses are regular people with jobs, families, and bills to pay. Asking them to stay brave through stress and pressure means lawyers also have to act like part legal strategist, part emotional support human. At the end of the day, intimidation tactics exist because they sometimes work, but preparation and documentation usually flip the script. The lesson is simple. Staying calm, staying organized, and staying loud about misconduct often beats staying silent out of fear. If any of this got you curious about how accident injury lawyers handle pressure tactics like these, you want to learn more about our company? Check out our links in the description.